Welcome to MBA Solutions. I am Manjunath, working as an assistant professor at VVC Mysuru. In this video, let us discuss doctrine of indoor management. Before going into the video, if you are not subscribed to our channel, please subscribe and press the bell icon to receive more notifications. So, doctrine of indoor management, what this says according to Companies Act. So, doctrine is, as we discussed in the previous videos, it talks about concept or principle. So indoor means any internal affairs of a company, and management means taking care of those internal affairs. So what does this tell or this provision tell? So outsider need not know what happens inside board of directors meeting or annual general body meeting of a company. See, before going into this, we should remember in doctrine of constructive notice, any person or an outsider should know memorandum and article of association thoroughly before entering into a contract. Since these two are public documents, they should know about that. But what happens in a meeting? What are the details of the meeting? Outsider need not know. Outsider need not know what happens in board of directors meeting or annual general body meeting. So this is called doctrine of indoor management. For example, see, outsider need not know how many employees were removed in this year by a company. So outsider or any person who want to have a contract with the company or want to purchase shares of the company or to become a shareholder, he might not know or he need not know how many employees were removed, how many recruitment happened. So he might not know all this because these are internal affairs of the company. Until and unless the company is doing good, until and unless the company is making profits, then shareholders are interested to invest in those companies. Whether they remove people or they don't remove people, that outsider might not worry about. So this is doctrine of indoor management. Now let us understand this in detail with a case study. So this case is a case which happened during 1856 in UK, and it is between Royal British Bank versus Turquand, who acted as a liquidator in this particular case. So what happened in this case? The company, that is bank directors, had approval in article of association. They had approval according to article of association of that particular bank that they can issue bonds and raise funds. So directors can issue bonds and they can borrow money or raise funds for the organization or the company. So how much they can raise? So that amount was not specified. So how much fund they can raise was not specified in article of association, and they mentioned in article of association that whatever amount you want to raise should be approved by the special resolution of the company. So now, but in article they have mentioned that directors can raise funds by issuing the bonds. Now what directors did? These directors issued around 2000 pounds worth bond to an outsider. So they issued bonds and they wanted to raise the fund. But what happened? They issued the bond, but directors could not get the approval in annual general body meeting for this particular raising of fund. They issued the bond. These people also paid the money and they took the bond, but it did not get proper approval in annual general body meeting. And at that time, at the time of liquidation of the bank said we will not pay money raised on bonds because there was no amount prescribed in annual general body meeting. So they said to the third party at the time of liquidation, see, you might have taken the bonds and you might have given some fund, but the bank will not repay it back at the time of liquidation because it has not, or this particular amount has not been prescribed in annual general body meeting. But these people, these outsiders said, see, in your articles of association, you have mentioned that directors can issue bonds and raise funds. How much that is left to you, because annual general body meeting is an internal affair. We don't know how much, because it has not been mentioned in article of association. According to article of association, you have just mentioned they can raise funds by issuing the bonds, but how much, that will be decided in annual general body meeting, and annual general body meeting is an internal affair. So we are least bothered about the internal affair. We have understood your articles of association and we have purchased bonds according to articles of association. So this is the claim that the outsider did, and even the Turquand, the liquidator, also said that the bank has to pay back the money at the time of liquidation to the outsider, but the bank is not ready to pay the money. Then they went to the court of law, and court said that outsider will get the money back because in article of association it is mentioned bonds can be issued, but to how much amount, to what extent, that will be discussed in annual general body meeting, which outsider may not know or he need not know also, because the outsider or the person who is contracting with the company will know only article of association. He need not know what discussion happens in the meetings, or let it be board of directors meeting or annual general body meeting. So this is called doctrine of indoor management. Doctrine of indoor management always gives a cushion, or maybe it always gives a support for an outsider, and doctrine of constructive notice always gives a support or always gives a protection to the organization, because in indoor management whatever they discuss in the annual general body meeting, outsider need not know. So he can enter into a contract and later he can evidently prove that he need not know what happened in annual general body meeting. But in doctrine of constructive notice, the outsider or the contractor should always know memorandum and article of association. So whatever the company mentions in MOA and AOA, based on that contracts will happen. So it is a protection to the company. Then the outsider or the person cannot say I don't know MOA or I don't know AOA. So thank you for watching the video.